Welcome everyone to this webinar. I'm Rafael Carmona from the ICDR. And before we start this very interesting session about Web3 disputes, I want to just take a moment of your time to remind you that you can join as an ICDR Young and International Y&I associate. If you look for us in our website, ICDR Young and International, you'll find registration forms in English and in Spanish. And in our website, you will also find the recordings of all of our previous webinars. We also have a LinkedIn group that's also called ICDR Young and International. So if you request to join there, you'll be also able to see all the updates that we will be posting in that group. With that very brief introduction, I'm very excited about this topic that I think is very interesting and recent. So I will give the floor now to our moderator, Rodrigo Franco. Rodrigo, the floor is yours.
Many thanks, Rafa. Welcome everyone to this webinar. Thank you all the attendees for joining us today, the speakers for making yourselves available, the ICDR Y&I and the São Paulo Arbitration Week for supporting this event. So just a reminder, please feel free to ask any questions you may have through the chat box. We are planning to leave plenty of time to answer them. And now I'm gonna make a brief introduction regarding the speakers. We have Bernardo Campos. Bernardo is a lawyer at Guandalini Isfer Oliveira Franco Advogados. He's doing a master in blockchain and cryptocurrency at the University of Nicosia. And he is also president of the Council for Digital Assets and Blockchain at the state of Paraná, Brazil. We have Lizzie Chen. She's a senior registered foreign lawyer at Allen Overy, Hong Kong. She's also registered in England and Wales, and he is in the Asia Pacific arbitration team based in Hong Kong. Now, and Juliette Asso, she's counsel at La Live, Geneva, and he is working with construction and infrastructure international arbitration disputes, among other industries. So now let's start this webinar with you, Bernardo. It'd be nice if you could share with us briefly what is Web3 and its main components: cryptocurrency, smart contracts, NFTs, and the Metaverse. So please, Bernardo, the floor is yours.
Thank you, Rodrigo. And I'd like to also briefly thank Rodrigo for the invitation, as well as to say that it is a pleasure to be here speaking together alongside Lizzie and Juliette about such a very interesting topic for all of us. And I'll try to answer Rodrigo's questions very briefly. However, it's not that easy to answer and explain to a big audience as this in a short period of time. So I'll make a presentation. I promise I won't take more than 15 minutes, okay? And so what is blockchain arbitration? How does arbitration and Web3 disputes relate each other? And what is Web3 that involves cryptocurrencies, NFTs, Metaverse, and smart contracts? I'll firstly just, where is my, just a second. Here. Well, I'd like to begin this presentation addressing why we are here today. And to put that into perspective, I'd like to ask you, what were you doing in 1995? Because if we were to compare the internet with blockchain technology, it would be as if we were still around 1995, 1997, when the internet had only 30 to 130 million users. And that is what blockchain technology has today. So the reason why we are here today is because we have a great opportunity in front of us to address issues, either professional or personal ones, and to dedicate ourselves eventually to this new market. And what is exactly this new market? To address it, I'll firstly explain what is Web 1, Web 2, and Web 3. And second, what are Web 3 components? And thirdly, to the main topic, that is, what is blockchain arbitration? So Web 1 started in 1990s, and it refers to the internet in which we only consumed content. It was read-only, read the news and so forth. Web 2 started in the early 2000s, and it refers to the internet in which we not only consume content, but we also create content. Blog, Twitter, Facebook, Amazon, we create content, we sell goods, and so forth. But it's highly centralized by the big players, Facebook, Google, Amazon, Microsoft, Twitter, and so forth. And Web 3. Well, Web 3 started with Bitcoin in 2008, and it has been growing ever since. And it refers to the internet in which I not only consume content, create content, but I also own content, what are now called digital assets. And this differentiation in the ownership of goods in exchange of values will create and is creating a ripple effect in all of our lives. And that is an event that we call and refer to as Web3. Okay, but what are Web3 components? The four main ones would be cryptocurrencies, smart contracts, NFTs, and Metaverse. Okay, there are many, many others, but for the purposes of this presentation, I will address the four main ones, starting with cryptocurrencies. Crypto is, by definition, a digital asset that is fungible. So there are several types of them. And to begin with, I'll like to explain Bitcoin because it is, although hard to understand, it will be easier to understand the rest. Bitcoin is a peer-to-peer, person-to-person electronic cash system. And there are several characteristics that define Bitcoin as what it is. It is a protocol of trust, okay? Think of it as that. And it has a messaging system that is called Bitcoin, and today has considered value, monetary value. A few characteristics: it is sovereign, or you have self-custody. You don't depend on a bank, you are your own bank. It is trustless, so you do not need to trust anyone or a government or a bank to transact. You can depend only on yourself and on the network. It is decentralized in the sense that there are no intermediaries. That is open in the sense that anyone can be one of these decentralized validators, even you and me. I myself have a node running right here, validating the network. It is scarce, limited to short of 21 million units, considered to be unhackable. It would need dozens of billions of dollars to hack it and still wouldn't have a lot of success. Runs 24 hours a day, 7 days per week, ever since 2009. I have not had not even 1 hour of instability, except for one event around 2015. And its rules are determined by its source code as well as the blockchain. There are also several other types of payment currencies. Bitcoin is only the main one, and also blockchain platforms or smart contract platforms. These are platforms. Remember, Bitcoin, you can only exchange one thing, Bitcoin. Ethereum, that is a blockchain platform, you can exchange many, many other things. You can create another token. I can create a token of myself, a token of this that represents the ownership of this phone. I can create smart contracts. I can create a contract on sales agreement or on a bet on who's going to win the game tomorrow, and many, many other examples that I'll give throughout this presentation. Okay, and it is considered in essence to be an entire financial system in and on itself. And for you just to have an idea, Ethereum, that is the main blockchain platform, once got to the value of $600 billion US. That's more than the 10 biggest US banks together. There are also stable coins that are attached to underlying assets such as dollar, etc., and any other tokens that I've said that we can create tokens of pretty much anything in the future. Everything will probably be tokenized. Here are some issues that may arise on legal related issues. I won't address them because it would take a lot of time. I'll leave it for Juliette and Lizzie. Okay, that's crypto. And now, what are smart contracts? Smart contracts are simple computer programs that run functions such as if this, then that. If you insert $1 in the vending machine, then one soda will pop out. They are contracts which in essence are a promise or performance given in exchange for another promise or performance. And that is what smart contracts do. Today, they are mainly used on-chain and by on-chain, I mean on the blockchain, and for on-chain purposes, such as exchanging crypto values, etc. However, we are seeing a growing use case, and there is a tendency for the future for we as lawyers to start combining smart contracts with regular contracts for them to work alongside each other, irrespective of whether or not they are related to crypto businesses. And here just a brief example of how a smart contract is. This is the eminence NFTs. And as I said, the probability is that in the future, everything will run alongside each other. And this is called Ricardian contracts. They are hybrid contracts that have both English natural language as well as code. A few examples of blockchains that work with Ricardian contracts. There are no, don't feel yourself, oh my God, the world is going so fast, I'm outdated. No, unfortunately, Ricardian contracts aren't, they are a real thing today, but there are no actual real application that you would use with confidence in any of your client in your law firm. So that is why I say there's a great opportunity to begin now. Few issues that may arise, I may address them later. And one point that I'd like to state is that we are seeing some type of lex mercatoria, which a few of us call as lex cryptographia, because we are seeing that some laws or some uses and customs are being created by this community, just as merchants created back on the old days and still do today. Okay, and NFTs, what are those profile pictures? Are there anything else besides that? Are there any real use cases for NFTs? Well, remember that when I give the definition of cryptocurrencies, they were every digital asset that is fungible. NFTs are digital assets, they are non-fungible. As I believe we have a legal audience, I don't need to explain what non-fungible means, but and the definition of NFTs would be any string of data on a blockchain that can grant you ownership of a digital and or physical asset and or the ownership of a right. And these are main types and applications of NFTs. So art, collectibles, streaming, every music, movies, etc., will one day become an NFT. And even,
Bernardo,
for instance, yes.
So, sorry to interrupt you. We have now a question for you. I'm gonna read to you. Do Ricardian contracts include a natural language clause like an arbitration clause? But smart contracts typically would not. That's the question. If you can, if
sure.
you want to answer now or leave it to the end, it's up to you.
Smart contracts are in essence only code that I myself, that I'm not a programmer, I would not understand. Ricardian contracts are hybrid contracts that have, on the one hand, code to run on a computer program that will exchange the value of these digital assets, but also they have natural language in each one of these code languages to make it easier for you to understand and for them to work hand by hand alongside each other. Both smart contracts that are not Ricardian contracts could have an arbitration clause. The difference by Ricardian contracts are that they are human readable and have only a higher legal effect by being human readable, but also work as code on a natural manner. I believe that may answer the question. A big problem that
Thank
comes
you.
with NFTs are associate terms of sale. So when you buy an NFT, be it a profile picture NFT, or be it, for instance, the Adidas or Nike NFTs, Prada NFTs, and so forth, they usually have associate terms of sale, but they almost always are not on the smart contract itself as a link or much less written. So I've addressed this issue by writing an article on NFT legal issues, and made an NFT out of this article and tried to solve these legal issues that even Adidas itself has not properly solved by inserting the contract and the licensing agreement for my own article. It was just an experiment within the smart contract. Here's just a print of the contract. Well, and the metaverse. The metaverse is also not something that today you are missing out. You can feel comfortable about that, but it is the future. And it relates to 4 big systems that are focused on gaming, entertainment, social, and professional. We are still quite far from like, oh my God, I'm going to be all day on metaverse as we are perhaps on Instagram today or so forth, but it is the tendency. And there are centralized metaverses such as Facebook, Swan, Microsoft, Sandbox, and Decentraland. Only Facebook so far has those that you can use the VR glasses, and decentralized ones that would work with crypto and depend on the community and so forth. So far, we do not have anyone that works properly with VR glasses and crypto. Here's just a few shots to give you an example. Although it is like, this is very small quality, low quality, it is impressive that when you are there, you feel that you are there, even if this is like on the Google browser. That's really impressive. Here are a few issues that may arise. And now to the final part of my presentation is about what is blockchain arbitration. And as we are focused here mainly on perhaps an arbitration community, I like to ask you a question. What do arbitrators dream about? And I believe that every arbitrator's dream is for us to have an arbitral legal order and for our awards to be rendered valid and enforceable all around the world. And funny enough, perhaps the blockchain technology has brought precisely that, a blockchain arbitration legal order. And why is that? And before jumping to the topics, there's even an article about that by Julian Liu. He has not addressed blockchain arbitration on this article. We do not know if blockchain arbitration will be a dream or a nightmare on autonomous arbitration, but it surely is a path that is being undertaken by many actors, especially those within the community that are crypto native users. Okay, so what are the advantages of blockchain arbitration? And actually just giving a step back, okay, on a technical aspect of how blockchain arbitration works. Smart contracts sometimes have what are called oracles. Oracles is the language that users call and are an outside source of information to a smart contract. Let's say that I'll make a bet on who's going to win the game tomorrow, and I need that information. That information is not on the blockchain. So there is a third party that has to bring that information to my smart contract. There are many, many different ways through which that happens, okay? But that may be considered an arbitrator. An arbitrator can also be considered when there is an actual dispute on a smart contract. I'll just give an example of how that would be. And the arbitrator works as an oracle on that smart contract that is essentially a multi-sig wallet in which the arbitrator holds the last key to sign and define what will happen as an oracle / arbitrator. Okay, and what happens when you have blockchain arbitration? The awards are handled and enforced instantly, and they are irreproachable on what enforceability is concerned, works all around the world, 24/7. Everything can be anonymized if they want and can be based on law or lex mercatoria. It depends. And here, just to conclude, a few examples of how would blockchain arbitration work. So there are use cases for on-chain arbitration, that is blockchain arbitration, okay, and not off-chain arbitration is what you guys know today. On-chain arbitration for on-chain issues. So let's say that is an insurance, and this is a real case, okay? You guys may know the dollar stablecoin Luna that collapsed in the value of $20 billion this year. In the Luna protocol, they were promised a interest rate of around 10 to 20% per year. An American investor invested $800,000 in the Luna protocol, but as it is a considerable amount of money, he made an insurance with an insurance provider on the blockchain that if the stablecoin dropped its peg to the dollar and it started to be quoted to 90 cents to each dollar and so forth, that person would be insured by that insurance platform. But the Luna collapsed and the insurance platform did not insure this person because they understood that the contract not apply in such a scenario. So they started an arbitration within Claros, and the claim was not provided by. But what was interesting that in this case, this guy, completely anonymous, hired a US law firm that signed the petition and everything within this blockchain platform and made the case saying that, no, that clause of the insurance should have applied because X, Y, Z, et cetera, et cetera. So we can see a real use case for on-chain arbitration that the arbitrators were chosen algorithmically by the blockchain smart contract. There are also on-chain arbitration for off-chain issues. So there are a case in Nigeria where there's insurance, for instance, that whenever there is like a natural disaster that ruins the farmer's farm, there is an oracle. There are actually physical physical gadgets that will measure the temperature. Oh, if temperature goes over 1,000 degrees, that's because it burned. So we are going to release the funds to the farmers. And the most interesting thing here is that these farmers before, they were not able to get the insurance from normal companies. So they had to resort to this blockchain initiative. And if, for instance, there's a discussion on whether or not the insurance would be granted would come an arbitrator to solve this issue. There are also off-chain issues that can be solved by on-chain arbitration. Any regular day-to-day problem, people stake values on an escrow account using a multi-sig wallet, and an arbitrator third party decides. And there's finally on-chain issues for off-chain arbitration and off-chain issues, but related to crypto for off-chain arbitration. And here is not exactly the topic of today's conversation, but it refers to the arbitration as you know today, solving crypto disputes. And now to conclude, I like to make pretty much the same question that I made in the beginning. And that is, what will we be doing in 2049, 27 years from now, exactly the same time from 1995, when the internet had the same number of users that crypto has today. And I believe that we'll very likely be working much, much more with blockchain technology. Thank you very much. And now I leave it to Rodrigo.
Thank you, Bernardo, for this introduction to the Web3 and its main components. Let's now turn to Juliette. Juliette, what type of disputes may arise out of the Web3?
Hello, everyone. And first of all, sorry, Bernardo.
Oh, no, I think it was for Juliette. I was reading the message. I got distracted, sorry.
Okay, thanks a lot, everyone, and thanks a lot, Bernardo, for this excellent presentation, because this actually it's paving what I'm going to discuss right now in a very well manner. So, as Bernardo explained, Web 3.0 is very wide, but today we focus on crypto, NFT, Metaverse, and smart contracts. So let's look at the types of disputes for each of these categories, and let's start with crypto disputes. And the reason I'm starting with this category is because, as you just heard from Bernardo, this is the first, the development of cryptocurrencies started much earlier than that of NFTs and Metaverse. So therefore, logically, now we have more existing disputes regarding cryptocurrencies than disputes regarding NFTs or Metaverse. There, we have already a bunch of commercial crypto disputes, and they mostly concern disputes between investors and trading platforms. And these crypto disputes concern first the trading of cryptocurrencies. And for example, you may have heard about the very well-known case where thousands of crypto investors sued Binance. Binance is one of the biggest crypto exchange platforms. They sued Binance in connection with the platform service outage that occurred for a few hours on 19 May 2021, which unfortunately was the day of one of the largest percentage drops in the value of the Bitcoin ever. So these investors claim that this service outage prevented them from selling their Bitcoins, resulting in huge financial losses. And they are claiming damages as a result. There are some other categories of disputes concerning the security of crypto exchange platforms, which of course can be the subject of hacking. There are also some disputes regarding the initial coin offering of cryptocurrencies. Initial coin offering is similar to an IPO, but regarding cryptocurrencies, there have already been a few cases in the US. But what is interesting for us, and I categorize ourselves as arbitration practitioners, and I apologize if it's not the case of everyone, is that many of these disputes are settled by arbitration. And this is because the dispute resolution mechanism provided by most crypto trading platforms provide for arbitration. And for example, in the Binance dispute I just mentioned, it is being settled at the moment under the Hong Kong International Arbitration Center rules. So next, NFT disputes. As you have heard from Bernardo in the chronology, although the boom of NFTs is more recent than that of crypto, there are already existing disputes in connection to NFTs. And they mainly, but not only, concern IP-related disputes. So the first category of disputes are disputes where NFTs are being created, and in technical language, you don't say an NFT is being created, but you say an NFT is being minted. So there are disputes where NFTs are being minted in infringements of copyrights or trademarks of third parties. So let me give you an example. Earlier this year in January, the French luxury group Hermes filed a trademark lawsuit against the digital artist Mason Rothschild for creating and selling Meta Birkin NFTs, which were depicting the company's iconic Birkin bag. And let me share a pic. So this is the NFT that was at issue. So Hermes argued that Mason Rothschild inappropriately used the Birkin trademark for his NFT, both the visuals, but also the name Birkin, which was included in the NFT's name, which was called Meta Birkin, and thus creating some confusion that Hermes was selling the Birkin bags in the metaverse. Mason Rothschild's defense was that it was just an artistic expression. So this case is still ongoing before the US courts, but 10 days ago, Hermes filed a motion asking for a summary judgment. So if this motion is granted, then we might soon know the answer to this interesting question, or whether you can mint, whether it is artistic expression, the fact of minting someone else's brand. A similar dispute is a dispute brought by Nike, also earlier this year, against Nike shoes reseller StockX for having used the NFT of Nike shoes without Nike's consent. But at the time when Nike was planning to launch its NFT campaign, and Nike found that this was creating confusion for consumers. StockX's position, which is very interesting, was that it was using those NFTs just to authenticate each physical shoes and to track them with customers. So this lawsuit is still pending, but the answer will be very interesting and have a huge impact for online resellers on the use they can make of NFTs. So another category of disputes are disputes concerning the scope of the IP rights, but sold before NFT existed. And a major source of contention is to determine whether they include the right to mint a corresponding NFT at a time where, in a contract, at a time where the NFT did not exist. So I'll give you an example. This issue was at the core of the lawsuit filed by the production company Miramax against Quentin Tarantino when he announced that he would auction off certain scenes of his handwritten script of Pulp Fiction as an NFT. And Miramax argued that Tarantino's NFT project violated their contract, but that contract was concluded long before the invention of NFTs. So unfortunately for us, unfortunately for them, this case settled last month. So we will not know the answer, but this is still a question in the air, and we'll need to wait for further court decision to know whether the scope of IP rights sold include the right to mint NFTs at the time where contracts, when contract was signed before those NFT existed. And another area of disputes are disputes concerning the scope of IP rights sold when selling NFTs. So here, when we know they exist. So does it include the NFT alone, which is, as Bernardo explained, just like the certificate, or does it include the NFT and the digital representation of the connected work, or the NFT and the actual physical connected work? So most NFTs are sold on marketplaces, such as OpenSea, without a comprehensive traditional contract or Ricardian contract, as Bernardo explained earlier, clarifying these issues. This is why there will be a lot of disputes. And last but not least, there are some disputes concerning errors in the smart contracts related to NFT transactions. So you may have heard of the CryptoPunk, and I'm going to share what is the CryptoPunk. Those little guys, which actually one of those guys is worth 23 million, so not unsubstantial. So there was an error in the coding of the first version, V1, of those CryptoPunks. So the NFT developer sent a V2 version to the owners of the V1 version, but corresponding to the exact same image. But because the V1 version could not be deleted, and this is because the smart contract code did not provide for this, a few years later, the V1 version resurfaced on OpenSea, which is the marketplace platform. So which was affecting the owners of the V2 version. And when you know the value of those CryptoPunks, this can have a huge effect. So this dispute is not before the courts, but this is an example of how errors in smart contract could lead to disputes. So last topic, Metaverse disputes. And this is the most recent, and as Bernardo said, you're not missing out anything at the moment. There are, to my knowledge, not yet existing disputes directly linked to the metaverse. And if someone is aware of one, please do raise it in the chat. But this does not prevent us from anticipating the types of disputes that can arise in the metaverse. So there are two categories of disputes: the disputes between users and metaverse platforms, and the disputes amongst users. So regarding the first category, the most obvious and predictable type of disputes that will arise, in my view, between users and metaverse platforms are disputes concerning the violation of users' personal data. It is, in my view, impossible for metaverse platforms to indefinitely guarantee the absence of hacking attacks. Another types of disputes are disputes concerning virtual real estate. Virtual real estate, for those who don't know, are virtual parcels of land that you can buy in the metaverse. Why? Simply because this is where there is a lot of money. So the total volume of transactions reached 500 million of US dollar last year, and is expected to double this year. And some single transaction reached 2.4 million, for example, on Decentralized. What increased the value of a specific plot of land is not only its location, but also its scarcity. because most Metaverse platforms, they guarantee a limited number of available plots. So what if, despite its current commitment, a Metaverse platform unilaterally decides one day to increase the number of plots? This would undoubtedly decrease the value of your investment. So you may want to bring an action against the Metaverse platform. The same goes if the Metaverse platform goes bankrupt or shuts down its servers. The value of your investment is then decreased to zero, and considering that some single transaction can go up to 2.5 million, this would have a serious effect. The second categories of these Metaverse disputes are disputes amongst Metaverse users. So you have the usual, I would say, unfortunately, crime and tort disputes, similar to what we encounter in the physical world, thefts of digital assets, sexual harassment practiced by one avatar on another, and unfortunately, sadly, there have been a case reported. But they also, and I think this is going to grow more and more, disputes regarding transactions between users. And this, you really need to understand that in the Metaverse, users can, without any control of the platform, they can offer services to other users, for example, offer a gaming experience, a concert, a sport coaching session. A user, they can create digital assets like wearable, accessories, art, and sell them to other users. And they can rent and resell parcels of virtual land to other users. But what if, for example, the digital Nike shoes or Adidas shoes you bought for your avatar do not have the color you thought? What if the virtual land you bought ends up not being exactly as described? What if, because of a technical glitch, you cannot access the concert for which you bought and you paid a ticket? What if the digital Chanel blazer or the Cartier Love bracelet you had bought for your avatar ends up being a counterfeit? And this actually happened in one metaverse, which is the Roblox metaverse. The issue being that the authenticity of what you're buying is not necessarily guaranteed by metaverse platforms. So because none of this is regulated, I would expect a lot of disputes, especially when amounts invested will be growing in the next 3 years. So this, in a nutshell, and it was maybe a longer nutshell than expected, is all the different types of disputes arising, Web 3.0 disputes.
Many thanks, Juliette. That's great. A beautiful overview of what type of disputes may arise out of the Web3. And for the ones that are joining us right now, we have already seen a brief introduction of what is Web3 and its main components made by Bernardo. Right now, we have just finished an explanation and an overview of what types of disputes may arise out of the Web3. And now we are turning to Lizzie Chen from Hong Kong, who will talk about the enforcement issues. So Lizzie, what are the enforcement issues under the New York Convention in relation to the Web3 disputes? If you could address these issues, it would be great. Thank you, Lizzie.
Thank you so much, Rodrigo. And I want to draw on the threads that Bernardo and Juliette have spoken about. So assuming that we already have a metaverse related dispute that's resolved by way of a blockchain arbitration protocol, and it results in an award, are there any enforcement issues under the New York Convention? And the reason for focusing on the New York Convention is because, at least in traditional international arbitration, one of its greatest benefits is the ability to enforce an award in almost 170 jurisdictions which are signatories to the New York Convention. And I recently co-wrote a paper with Emily Hay looking in more detail at different parts of the New York Convention to examine the enforcement issues that might arise. The first question to ask, though, is whether the New York Convention will even have a role at all in the context of metaverse-related disputes. And you've already heard from Bernardo talking about how smart contracts are self-enforcing. And there are there is at least one digital dispute resolution rule that I'm aware of in the UK, where the rules empower the tribunal to directly enforce the awards by modifying, changing, or transferring, or in some other way dealing with the underlying asset. Or you might have a situation where the parties agree, say they put some cryptocurrency or whatever into escrow, and whoever wins the arbitration is then automatically receives the proceeds that have been put in escrow. Now, in that situation, you might not engage the New York Convention at all because you already have a self-enforcing mechanism. But there is a great possibility that on-chain arbitration may nonetheless result in an enforcement issue that needs to be dealt with off-chain. So so an example would be if the award was to be enforced against physical assets in a particular jurisdiction, for example. And in that regard, we might encounter issues under the New York Convention, and I'm going to quickly consider a couple in the next few minutes. The first is, under the New York Convention, you have to have a valid arbitration agreement that has been signed by the parties or agreed by an exchange of telegrams. Bernardo's already given us a very persuasive explanation of what smart contracts are, Ricardian contracts, and I asked him a question about whether these contracts include or incorporate international arbitration, dispute resolution clauses. There is a question about whether a smart contract or whatever contract is entered into will be considered valid for the purposes of the New York Convention. Is there going to have been proper notice of the arbitration agreement if it's to be incorporated by reference to a smart contract? And will the smart contract comply with any mandatory laws, for example, consumer protection laws? So that's a threshold question under the New York Convention. The second issue that might arises from the lack of identification of the parties. And Bernardo's already talked about transactions on the blockchain. And in many cases, you can transact anonymously or pseudonymously, or it's in some way difficult to identify who the parties are. Now, there's a question about whether the potential anonymity of parties or even arbitrators in metaverse-related disputes that are resolved by way of a blockchain arbitration protocol would pose an enforcement risk under the New York Convention. And at least the issue of identification or anonymity will go to issues of formative consent and also substantive consent. As many of us know, a fundamental aspect of international arbitration is that the parties agreed to arbitrate their dispute. But if you don't even know what the legal identity of the parties are, how do you even determine whether they agreed to the dispute? And there are some grounds for challenge under the New York Convention, for example, whether a party had the capacity to enter into an arbitration. It can be difficult for a national court to assess whether a party did have capacity if it doesn't even know who the party is. The New York Convention also requires arbitration agreements to be signed by the parties, which might suggest that you actually need to know who the parties are, although the New York Convention also refers to arbitration agreements concluded by way of an exchange of telegrams. So perhaps there's space there to accept arbitration agreements where you don't know who the parties are. Our third point is issues around due process. So due process is protected under the New York Convention as the party's right to have proper notice of the appointment of the arbitration proceedings and being able to present its case. Really, due process is a very broad church, and in international arbitration that can arise, or breaches of due process can arise in many ways. Did a party have the ability to present their case? Did the arbitration tribunal decide the case based on what the parties had argued? Or if there was another relevant point, did the parties have the opportunity to comment on it? Now, due process is often seen as something very, very important in international arbitration, but a question might arise, in the context of blockchain arbitration. Are there certain breaches of due process that might be acceptable for the purposes of the New York Convention. Now, Bernardo has already explained blockchain arbitration, but just to recap, some of the key features would include, you have randomly selected anonymous jurors who are economically incentivized to vote in accordance with what they think the majority of the jurors are going to vote. They're not generally required to give reasons for their decisions. They don't have to meet and confer on the decision making. They're not subject to disclosure obligations. And they don't even need to be legally or technically qualified to be an arbitrator. Now, just listening to those different elements, we might think that some parties might, at the enforcement stage, raise issues with these. So, for example, they might say, well, they have the right to appoint the arbitrator and to appoint somebody whose identity that they know. A party may say, well, an arbitrator's duty is to apply the law to the facts and not be incentivized in an economic way. You could say, some parties might say that arbitrators are supposed to give reasons for their decisions. They're supposed to meet and confer on their decision, even if each arbitrator comes to their own individual decision. And for the independence and impartiality of arbitrators, some parties would say that even jurors, anonymous jurors, should have to make such declarations of independence and impartiality. Now, an issue that arises, and which would be really interesting to discuss, is whether there are any limits to due process. One of the core tenets of international arbitration is party autonomy. So are we in a world where the parties can agree to whatever process they like, anonymous arbitrators or not, so long as they're happy with it, it should be fine? Or are there some bottom line or some red lines that can't be crossed? And in international arbitration practice, there does seem to be some red lines. So, for example, under the IBA guidelines on conflicts, there are some non-waivable red list categories of conflicts that we think that parties don't have discretion to agree to. We currently give parties a lot of discretion as to the choice of law that the arbitrator should apply. Fernando, I think before mentioned ex quiet and bono or lex mercatoria. We also have baseball arbitration, where the tribunal is limited to choosing one side's arguments over the other, which does in some way resemble a binary decision that jurors in a blockchain arbitration may have to reach. There's been quite an interesting development by Koala. It's a coalition of people who drafted a model law for interacting with DAOs, so decentralized autonomous organizations, where they've stated in their model law, they've just stated that anybody who engages with a DAO and resolves their decision by arbitration agree that current systems of arbitration do not meet minimum standards of due process, and the award should be recognized and should have the status of a foreign arbitral award. In my mind, I can see this to be a creative way to try to meet the due process issue, but there's a question in my mind whether such a unilateral declaration, even if made by a party, would be acceptable. Can you simply agree that minimum standards won't be applied, but still insist that an award will nonetheless have the status of an enforceable award under the New York Convention? So that's just a quick whirlwind tour of some of the issues under the New York Convention. I think there's a bigger question to ask. Some big questions we can discuss are, is the New York Convention even relevant? And two, if it is, do we need to rethink traditional concepts of due process, for example, or legal seat? I didn't quite get to this in my presentation in the interest of time. Do we need to rethink those? Or if we think the New York Convention is not relevant or not suitable, then do we want an alternative enforcement system for awards that are resolved through blockchain arbitration? I think those are questions that the international arbitral community should grapple with. Thank you very much.
Awesome. Thank you, Lizzie. We have a couple of questions now in the chat box. And so the first one from Simon Murmur is the following: can parties circumvent a national court's review under the New York Convention by referring their disputes to certain arbitration rules that allow self-enforcing mechanism. This is the first one. Lizzie, I don't know if you wanna take this one. It's in the chat box.
Yeah, so I think that if an award is self-enforced, and in fact self-enforced, you don't circumvent the national court review system in the sense that you don't actually need to refer the dispute to a national court at all. But even if you chose rules that allowed for self-enforcement, but you still end up having an award that you need to enforce against, say, physical assets in a particular jurisdiction, then I don't think you would be able to circumvent national court review. So long as you need a national court to step in and intervene in some way, you would need to ask the court for assistance. Yeah, thank you.
Thank you, Lizzie. Now we have another one. That's from Scarlet Riot. Do parties even have a right to sue someone for the conflict which occurred on the platforms which are essentially like international waters?
I can start to answer this one, maybe Lizzie and Bernardo if you want to add. So that's I think one of the biggest issue at the moment. If it depends of who needs to be sued. If you're a user and you want to sue like a platform, then whenever you click to enter the metaverse, you need to agree to terms of use. And then those terms of use, you never read those, you always click OK. But they include a dispute resolution clause, which allow you to have your dispute settled. So that's more or less clear, although you still have some issue, what is the real entity, because all those metaverse platforms, they have different corporate entities, and this is not always official, what is the structure. But the issue is if you have a transaction with another user, another avatar, who do you sue? And that's the issue, because as Lizzie mentioned, first, you don't know who is behind this avatar. You may have the wallets, the address of the wallet, but that's the maximum you can have. And also the issue is you have never entered formally into a formal contract. I mean, if you have some transactions, you obviously have smart contracts, but as we discussed earlier, smart contracts most of the time are just code, and they do not include always natural language with an arbitration or other dispute resolution clause. So that's where I think at the moment there is a bit of a void, and most platforms, they actually have in the terms of use, they have sort of a waiver provision where they are saying, whatever happens between users, stay between users, we are not involved, we're not responsible. So that's, in my view, also one of the issues.
Thank you, Juliette. Not sure if Bernardo and Lizzie want to complement on that. Please,
yeah, I like to jump in to talk about both questions and also address a bit other questions that came right after. We may be already considered to be right now in the metaverse. I'm at my home in Curitiba, Juliette, Geneva, and Lizzie, I think Hong Kong. Which law applies if I commit a crime here, or if I steal someone's access to Zoom's platform? The only difference between the metaverse, which we're speaking here over the past half an hour, and the Zoom call, is that we are not using VR glasses. So, and we are not very interactive, like I can see one's body, etc. We are just like a screen on the screen. And eventually the fact that I may not be able to identify someone else, but that will be pretty much the same thing as I would not be able to identify someone's handle here in Zoom if this was not a closed event and required you want to subscribe to it. So what I'm trying to say here is there's not another planet or world, and nodes that run the blockchain, such as a computer that I live here running the blockchain Ethereum platform. They are somewhere. They are in Brazil, they are in Russia, they are in the United States, and so forth. So one law will very likely apply to it, in the same conflict of laws, very likely, that would happen in a Zoom conference such as this. Perhaps one day, if it becomes so real the metaverse, one may argue, or there may be a law that will state, oh, so for events happening in XYZ circumstances in the metaverse, as it may be a free world, you know, it may not apply any law, it will apply, I don't know, but on the current state of things, I believe that is the same thing as we were on a Zoom call. And we just want, I want to compliment Lizzie's talk before, but then want to interrupt her, or perhaps it was Juliette, when saying, oh, there's a dispute because my avatar this, avatar that. Juliette explained very well, and sometimes I myself think, oh, this may be silly, it won't happen, I won't fight over my avatar. But when you use VR glasses and you experience it, it seems silly now, but it is like really, really important. And this today with the very low quality of image and so forth. Imagine 5-10 years from now when quality is like excellent and people will spend days and days in there. So, and then it's amazing how you attach value to things that you have over there.
Thank you, Bernardo. Lizzie, please.
One additional thought is, Skyly, you raised an interesting point about whether the interaction in the metaverse should be like akin to interacting in international waters. And I don't think that we currently apply concepts of international waters to activity on the internet. I think even activity on the internet, you know, is like that there are like national jurisdictions will have rules about where conduct occurring in the internet is deemed to have taken place. Okay,
thank you. We have more questions here, guys. The next one is from Andrew Riccio. That's the following. If the disputes arise from a contract that was negotiated, executed, and performed in the metaverse, is it an international dispute under the New York Convention?
I'm happy to have a go at this. I think under the New York Convention it applies to foreign arbitral awards, and that's usually understood as an award that's made in the territory of another state. And I think probably the metaverse would be treated like contracts now that are negotiated, executed, and performed on the internet. That'd be like, probably it will be up to the relevant jurisdiction, the courts of the relevant jurisdiction, to determine if the contract or the award resulting from it would be considered a foreign arbitral award. I don't know, Juliette and Bernardo, do you have additional comment?
Go, Bernardo.
Bernardo is on mute. So go,
I know he's actually a gentleman. so I think that like in this case, it would be an international dispute, because I think the nature of transactions in the metaverse are international by nature, as Bernardo explained. Not only like the people are from all over the world, they are not connected to a state, but also they are stored on a blockchain, which is another layer of international level. So I would consider transaction in the metaverse as international transactions, and therefore an international dispute.
I think it depends. On Lizzie's side, regarding the international aspect of the award, for instance, what she said is correct. It would depend on the aspect on where you are enforcing and so forth. But whether or not the dispute itself would be considered an international dispute as to which law would apply to the merits or to the procedure, I think it depends on the facts. If we are considered to be in the metaverse here today, and I have a dispute with Rodrigo that is in the same country as I am, perhaps the Brazilian law will apply. Depends on the law that applies to the Zoom platform, which I believe it is based on the US. So I think that one will have to do the conflict of laws to see, is the metaverse platform on the US as well as both of the parties. I think that the US law would apply, not necessarily international, unless, and here briefly addressing God's love offer question, is on whether or not laws or regulations that apply to the metaverse or Web3 will be based on jurisdiction or will there be a globally recognized regulation that applies to the metaverse? We don't know, it depends on legislators. So it may make sense to have some kind of concessions and laws that apply to the general aspects of it. But I think that at the end of the day, no country will give up on at least some core set of laws that are intrinsic to them.
Okay,
So
thank you,
yeah,
Bernardo.
at the moment it really depends on the court's interpretation, because there are no regulations at the moment. It's just for example, UK courts, they have made some interpretation. There was a case about cryptocurrencies, and the question was, where do we find that those cryptocurrencies are located? And they decide, so the local courts, the UK courts decide, okay, because the owner is based in the UK, we consider that those cryptocurrencies are located in the UK. So this is just a random interpretation from one court, but I think, like Bernardo, that if we want to avoid a complete mess internationally, we will need to have at least some guidance, if not international rules. For example, the Hague Convention could create some convention like this for the choice of law and jurisdiction rules, and we should have some principles like that everyone, at least all the states, tend to interpret in the same way.
Okay, thank you. Yes, Bernardo, please.
No, Lisa, go first, please.
Oh, thank you. I just wanted to raise an interesting question about like how we treat global commons. Why is it that the seas, we have like specific rules about the seas, and there's like an international system. I don't know much about space, but I think there are international law rules that relate to outer space as well. But actually, if you look at the internet, it's not treated in the same way. And it's still like, we think of the internet as like being borderless, but actually in many ways, the internet is territorially segregated. The internet in China, what you can access there is quite different to what you would be able to access in other parts of the world. So I think it's just interesting, where will the metaverse fit? Will it be closer to how we deal with the internet? Or, which I think is probably the case, given, it's about like accessing this virtual space. Or might it be something more like the high seas or outer space? That's it. Thank you.
And I think that it also depends on the merits of the dispute, because if it is a criminal aspect, I'm sure that there will be specific laws and conflict of laws for that. If it is related, for instance, to securities, I'm sure that the SEC, that is Securities and Exchange Commission from the United States, will understand that if my avatar offers a security to Juliette, or to someone, or actually someone that would be based in the US, securities law and US law, securities law from the US would apply. So there's one thing to take into consideration as well.
Thank you all. Now we have two more questions in the Q&A. That one, Juliette have already answered. I'm not sure if Bernardo and Lizzie, if they want to comment on that, is the following. Under the current arbitration regime, is it possible to have a mass claim arbitration involving crypto-related claims?
Yeah, so,
I think so. Yeah.
On the aspect, at least, I think Lizzie, Juliette answered the aspect regarding normal off-chain arbitration. So jumping to address on-chain arbitration. On-chain arbitration.
Just technically, can everyone see the answer from the Q&A, or is it just the person who has
Everyone.
Yeah, I think I can see it. Yeah.
Okay.
Yeah. I guess. Sorry.
Yes.
No, someone said no. Andrew said no. I think it's only the panelist. So the answer, the quick answer was yes. So the Binance arbitration that I referred to earlier was an example of mass claim. There was a Swiss third-party funder who had gathered hundreds of claimants to sue Binance. And I can put in the chat the link to the article if you want to read more about it. And now I pass the floor to Bernardo for the on-chain answer.
I've sent the questions and answers on the chat. On-chain, as a blockchain platform, it is programmable money, programmable everything. So you can program a arbitration to happen as you wish. And just complementing something that Lizzie said before, indeed today, blockchain arbitration platforms, which are very few, also not missing out on anything right now. There's Claros that is still like baby steps, very far from being something that can be widely used for many different cases. And there are others that are not even online, one or two that existed and now are no longer working. What I'm trying to say here, today Claros has already evolved a little bit, so you can not, the decision does not necessarily has to be A or B. You can, if I'm not mistaken, leave it open for the arbitrators or jurors, as they call, to insert, for instance, another value as for the award to be rendered and other options. And I do not believe that Claros platform allows today for you to choose the arbitrator, but you just need to draft a smart contract that allows that. So pretty much every single thing and more that we do today can be taken to on-chain arbitration.
And if I can pitch in, I think the question of mass claims and arbitration will really depend on the applicable rules. And I'm not aware of that many, if any, arbitral rules have really developed sophisticated provisions in relation to mass claims in the same way that we see that in the courts. Like there are very developed, in many jurisdictions have very developed procedures about class actions. So I think this is definitely a developing space in terms of procedure, whether that's driven by tribunals in a particular case or by institutions and reforming their rules.
But one thing that would be amazing, let's say an insurance on the farmers over there in Nigeria, or the smart contract protocol that would insure the stable coin against a DPEG of the dollar. Let's say that there is one arbitration, and in accordance with the rules of the arbitration of this one client that is requesting the insurance that was denied is granted, you can set the rules for all of the other 1,000 or million of victims to also have the same effect, and for the funds to come out of the insurance company to all of the clients at once, instantaneously, 24/7 around the entire world. And answering to Andres' questions regarding will the dispute, and I believe law applicable to the dispute, depend on whether or not the dispute is in the metaverse. My God, wait. It will depend if the dispute in the metaverse is subjected to arbitration or not, won't it? Well, if you make an analysis as, okay, in arbitration, perhaps depending on the country's law, I can choose if it is an international dispute, the law applicable to it, if it is arbitration, if it is a court that may be more difficult to do so, then one might argue that, yes, it would depend on whether or not one would choose arbitration. Perhaps there's some country around the world that prohibits that. I believe it will depend on the country's law.
Just to complement on that, Bernardo, are you, Bernardo, Juliette, and Lizzie, are you seeing arbitration clause in these metaverse contracts and smart contracts and so on and so forth? I think Andreas' questions goes towards the option, the dispute resolution clause, if these contracts are using arbitration or not.
Yes, many of them are. I'm not speaking on behalf of metaverse related. I'm not so metaverse as Lizzie or perhaps even Juliette. I'm more to the side of DeFi and crypto. But on what DeFi, crypto, and NFTs are concerned, yes, many projects of NFTs or crypto, when they are launching their token, they have either on terms or conditions, there's a PDF on the webpage of the website, or eventually in the smart contract itself, although very rare, is arbitration provision. But many, especially NFT projects that are created in-house by teenagers or enthusiasts, have pathological or for some reason definitely not applicable arbitration clauses.
Okay.
What we see a lot, just to complement on what Bernardo said, is NFT. I mean, for Metaverse, it's more about the NFT you see for the smart contract, because every digital asset you buy you purchase in the Metaverse is actually an NFT, which can be a piece of land or a wearable. So the question, the underlying question is then, can you put an arbitration clause in the smart contract for an NFT? So most projects, most NFTs, the issue is they do not have the language of the code in the smart contract, which is mostly code. But what they often have, but not always the case, but they sometimes have, is a link to the website. For example, you might have seen a lot the Bored Ape, a very famous NFT where you see a monkey face. What they have is they have a link, like general terms of condition, and a link to the website. The issue is the website then can have some terms of use and can have some arbitration clause. But I'm just brainstorming with everyone here, but this website can be updated. So maybe at some point in time, it will have an arbitration clause. At some point, it will have nothing. At some time, it will have a code clause. And what would you and this NFT will be sold to different people. So the question in terms of consent, do you first expect someone to be able to go into the code of the smart contracts, which is kind of sibling for some people, and be able to see this reference to the website? And second, are you supposed to have read all the different links, including the link in the website? For me, in terms of consent, that would be an issue.
Right.
I like just to give an example of disputes that may arise in the future regarding Metaverse, as it is already today, regarding sales and purchases agreements, or even companies, not necessarily only consumers against consumers or consumers against the platform or NFT sellers. In Metaverse platforms, you can, as a person or as a company, create NFTs and sell it throughout the platform. Of course, the platform needs to accept it and so forth. So there may be disputes between Nike and Decentraland, that is a decentralized platform, on whether or not there was a breach of contract regarding the way that the NFTs were displayed in the Decentraland platform, because Decentraland is still responsible for the graphics and so forth. So we are seeing here that there is really room for bigger and bigger disputes, definitely not only consumer disputes. If one of you have already read the articles that have been written regarding arbitration and Web3 disputes, most of them kind of focus on consumer disputes. They say that they would be a way to address them, indeed, but actually I tend to think otherwise, that in DeFi, okay, there is a growing use case for arbitration that will grab types of disputes that happen today regarding financial markets, and it will go to DeFi markets, that are decentralized finance, as arbitration for bigger claims.
Beautiful. Thank you so much. I think we have a final question here. We are almost 15 minutes past an hour. With still a great audience. Thank you very much for all the attendees. We had more than 130 people, and still now around 90 participants. So thank you very much. That was beautiful. And let's go through the last question I'm seeing here from Surya. So that's for you, Lizzie. I believe that you mentioned a coalition drafting a model law on enforcement of blockchain awards. Could you repeat the name? Okay, you have answered already. Coalition of Automated Legal Applications. So I think we have answered all questions. Lizzie, Juliette, and Bernardo, do you want to comment on something, or do you have any final comments? Please.
Just a big thank you very much. Yeah, same.
And next one we organize in the Metaverse.
Yeah.
Yes.
Oh, I have. Guys, I have created an NFT to all of you. That is a
Yay.
certificate of participation. I'll send on the chat. Each
Awesome.
link will only work once. So I'll send around 100 here. I believe that most of you very likely won't
Thank you.
request it, but where is the chat?
For those who haven't an NFT yet, you first need to create a crypto wallet, and this is an excellent time to do it because you will need it for the next 10 years for sure. So if you start now, you will be in advance.
Yes,
Great.
and this NFT is just an NFT that proves that you participated on these events. And what I like to just conclude with is that we are still in 1995. So things are still very on its early stages, and it's a great opportunity to every single one of us to try to explore this world, either professionally or personally, because it is the future. And it's growing, the adoption rate is growing even faster than the internet. I think that is it. Thank you very much, Juliette, Lizzie, Rodrigo, the ICDR. It was a pleasure.
And thanks for me. Thank you.
Thank you. Just to clarify for the attendees, you get all the attendees that have registered for this event. You get an email from the ICDR Y&I with a link to this recorded session. So you get that. And I think Bernardo, someone asked to share the PowerPoint presentation. So
yeah, if you hold on 30 seconds, I'll export it to PDF and I'll send it right away.
Okay. So while you're doing that, I wanna, on behalf of the ICDR as well, I wanna thank you all the attendees once again. Lizzie for making this big effort to be in Hong Kong right now and still recovering from COVID, right, Lizzie? That was great. And Juliette in Geneva, that's a city that is really on my heart. And Bernardo also for gathering and making all this event possible as well. So thank you very much. Bernardo is now have already shared his presentation. And please, if you have any further questions, you can ask through LinkedIn, and also you can find us on the media as well. Thank you very much, and have a nice day, you all, and see you hopefully soon, personally, if possible.
Or on the
Bye-bye.
Metaverse.
Thank you.
Thank you, everybody.
Bye, everyone.
Bye.
Bye.